Honourable Members, the House is in committee on the Crown Minerals Amendment Act 2013 Amendment Bill. The question currently before the committee is that Part 1 stand part, and that is debate on clauses 4 through to 6.
Mr. Chair.
I call the Honourable Member Grant Robertson.
Thank you, very much, Mr. Chair. It's a privilege to take a call in the committee stages and from you, Mr. Chair. It is, of course, in the real world Friday night. I'm here under some level of sufferance, although I have now learned that the Chiefs, in fact, did beat the Hurricanes 17-12. I personally blame the national government for that result. Had I been at the game, I am quite sure there would have been a different result than that. So that will make my contribution to this bill perhaps even longer than it might have been had the Hurricanes managed to win that particular game. Mr. Chair, as you noted, this is debate around clauses 4, 5 and 6, and this is the bit that Simon Bridges tried to tell us was the original policy intent that just got missed out the first time round 6 weeks ago when the Crown Minerals Amendment Bill was going through the House. I think Simon Bridges should actually just keep amendments to the Crown Minerals Act as a standing item on the order paper. That'll just make things easier. We'll just come back to it once a month, correct all of the mistakes that Mr. Bridges makes, and then he can just get on with making a few more, and we'll come back and correct them as the House is now having to do here in Part 1 of this bill. And in all seriousness, Mr. Chair, it is concerning that on an issue of such importance to the government puts a lot of store in the question of minerals extraction and what that will mean for New Zealand in the future, that the government is so sloppy in its lawmaking on that issue. But that's not just the end of the matter, Mr. Chair. The fact is that they are sloppy in an area where health and safety concerns are huge, where environmental impact is massive, and this government has been completely loose with its lawmaking. We saw it in the Exclusive Economic Zone Bill, and we see it again here in the Crown Minerals Amendment Act 2013 Amendment Bill. We need a proper regime around these matters. These are matters of great significance to our economic and environmental future, and it simply isn't good enough to have to be back in the House 6 weeks after this bill went through, making yet another amendment to it. Mr. Chair, Part 1 of the bill, as the Minister has alluded to, changes the process for what happens with particular types of Tier 1 permits. This is where there has been a permit granted for committed work, and that committed work is undertaken, and a different company is now allowed to undertake the later work, the contingent work. And I have some questions for the Minister and the Chair which I'd like him to answer around Part 1. And in particular, I would like a further explanation about exactly why it is that this did not appear in the first version of the Crown Minerals Amendment Act 2013. Because, Mr. Chair, it seems to me to be a fairly significant matter. The fact is that the government clearly intends it, that there can be new prospectors come into the process of work under this legislation at a later stage than what had been envisaged when the Act was passed. And looking through the material, the regulatory impact statement on the last version of this bill, we don't have one on this version of the bill, it was quite clear to me in reading that actually this wasn't envisaged. This actually wasn't envisaged. There was a process that was gone through to talk about what would happen with permits, but when you actually read that original regulatory impact statement, I can't see that the government did intend for this process to occur. So I would like the Minister to take a call and ask us, how is it that it was missed out? If it wasn't just missed out, what's changed? And that's my second question for the Minister. And it's the question I think a lot of people will be asking: who's spoken to the Minister? Who's come to the government in the last 6 weeks and said, guess what? You haven't allowed for what we want to do. And Gareth Hughes mentioned this in the earlier readings of this bill, that there are companies wanting to work and for instance in the continental shelf around the question of protesting, which we'll come to in part 2. But what happened here? Who was it who came to the government and said this permitting regime that's been changed here under clause 6, who wanted that change? Because that's an important matter, because the track record of this government, Mr Speaker, is to kowtow to corporate interests, to vested interests when they come knocking, be it Warner Brothers or be it Sky City. They'll bow down, they'll say that's all right, the laws are for sale. Well, who was it in this case, Mr Bridges? Who was it who came to the government and said, we think we need your law, Mr Chair?
Grant Robertson.
We think we need your law changed. So that's the question Simon Bridges needs to ask. Why are we changing this today? What went wrong? And who was it who wanted it changed? And Simon Bridges should take a call and tell New Zealanders the answer to those questions. Mr Chair, when we look at the changes that are suggested here, I do have some significant concerns about the process. If we work through the process, an applicant for a Tier 1 permit for exploration who doesn't have the expertise or financial ability to undertake the exploration drilling activities can be granted a permit on a conditional basis, and the permit holder can undertake that, what's called committed work. It's essentially seismic surveys, and then after that they can, acting as the farminee, farm out their rights effectively. And this, as the government would like to tell us, provides us with a different route for this exploration to take place. Now, the two key elements to making this work, Mr Chair, are whether or not this can be managed through tighter permit conditions. And the tighter permit conditions have to be put in place and monitored by the Minister. And that's the concern that I have, Mr Chair, is whether or not the management of these permit conditions can be undertaken, and we can have confidence that they will be undertaken by the Minister in the way that we want. Because again, the track record of this government is one where if corporate interests come to play, the government will back down. And if we look at the new clause 29B3, we say that a permit is granted in accordance with this section. Work cannot be undertaken after the Exploration Drilling Committee date unless before that date the Minister has, upon application by the permit, satisfied him or herself of the matters set out in 29A, 2, B and D of the original Act. Those are the matters around health and safety. So what they're saying is the Minister has to satisfy himself, in this case himself, around the matters of health and safety. Well, what confidence do we have in this government to do that? I do not believe the track record of this government is such that we can say we have confidence that the Minister, satisfying himself as he has to do under section 29B3, would actually do that in the interests, I thank my colleague Megan Woods for that, I can actually do that in the interests of New Zealand people. And that is the problem. Now, the permit holder themselves then goes on to be able to do the drilling and so on that was originally envisaged in the initial permit. So at that point in time, a new player has entered the New Zealand extractive industries, has gone into our pristine environment and has decided that they would like to be involved in this. They've picked up a permit that somebody else has got. What confidence can we have as a parliament passing this law under urgency that we have in place all of the rules and the regimes to ensure that if a new player comes in, that we can have confidence in them? All we've got under this law is Simon Bridges to give us that assurance. That's all we have. And given his track record coming to this House 6 weeks after he put up the last bit of legislation to amend the mistakes he made then, does that give New Zealanders confidence that he is the one thing that stands between some kind of cowboy player entering the New Zealand extractive industry sector, thank you, it's very late, New Zealand extractive industry sector, and the one thing that says will this new player be up to it, is Simon Bridges the Minister. And Mr Chair, I simply don't believe that 29B3 provides us, the new 29B3 provides us with the kind of assurance that New Zealanders would expect. So Mr Chair, in part one of this bill, that is the substantive matter that I want to raise. I simply do not believe that the government has made the case for why this change has been made today. We need to hear from the Minister to tell us why this has happened now, who's come to him and asked him, and then we can actually start looking at the detail of whether or not we have sufficient rules and safeguards in place to ensure that any new player entering the extractive sector has the attributes that we would expect of them. Mr Chair, this is sloppy lawmaking from the government, and this section of the bill needs significant work.
I call the Honourable Member Moana Maki.